Good afternoon, everyone. Chris Kent Sorensen and Perry McLennan here, and back to talk to you again about COVID-19. As always, any questions that you have, drop them in the chat box, the Q&A box, and we'll answer them best we can as we go, as well as address them in general session. Again, we always welcome any conversations, any questions that you have. And are glad to talk about really about anything that you might be facing right now with regard to COVID-19, return to work, and if there's any impact on your businesses about the protest. So with that, we'll go ahead and get started, and Perry's going to kick us off.
All right, thanks, Chris. Welcome everyone to another installment in our Zoom series on COVID-19, which is still very much with us. So we wanted to check in with everyone today and provide some relevant updates and hopefully get some feedback from all of the participants on sort of what you're seeing out there on the front lines as operations are starting to get back up and running. So just quickly, a little bit of an overview of what we plan to address in today's webinar. And as Chris mentioned, we're happy to answer any employment related questions that you have. We're going to do a quick update on sort of where things stand, both from a public health perspective as well as a business perspective on returning to work. Give kind of an update on COVID-19. I'm going to do just a very brief mention of the Paycheck Protection Program. I know some of you may be intimately involved with that at your organization, and others, it may not even be applicable to you. Give everyone a legislative update on what Congress and the state of South Carolina are considering at this point in time that could be relevant to your workers. And then just the latest from the regulatory agencies that we continue to get, the CDC and as well as the EEOC and Department of Labor, as it relates to coronavirus. So I think where we will start is just by giving a sort of an update on coronavirus in South Carolina. Most of you are like me and are probably following the news of this very closely. We get updates in the paper every day from DHEC about where things stand. On the next few slides, I have a couple of charts that this first chart shows basically the trends by state for where COVID is. The second chart is showing South Carolina as being one of those states that is seeing one of the greatest percentage spikes. So as some of you know, that this really was particularly bad in sort of our metro areas throughout the United States at first. And we've sort of moved into this second phase now where some of the more rural areas are starting to see greater increases, where places like New York are decreasing. So you can see this chart here that we're looking at now. Places like Arizona, Virginia, Alabama, South Carolina are seeing, pretty substantial increases on a percentage basis in COVID cases. Ours in South Carolina for total cases are still relatively low at 11,000. Although if you look at the per 100,000 number, you'll be able to see it on a per capita basis a little bit better. But you can see you can see the graph there that's showing South Carolina increasing. Monday and Tuesday of this week, we were getting, around 300 or more new cases per day, which is an increase of what we were seeing before at around 200. And there are two reasons for that. And number one is increased testing, obviously, is discovering more positive tests. in addition to that, obviously restrictions have been eased. People are not, staying sheltered at home as much, and so the cases are going up. And I think it's important to point this out at the top, just to sort of serve as a reminder to everyone that things aren't, COVID perspective, things aren't necessarily really improving from just a case number standpoint. So I would not expect to see a huge drop off in requests for leave and issues regarding COVID, in the short term or really in the medium term either. I think we're obviously still, in the thick of this public health fight, and could be for quite a little while. Brittany, if you could go to the next slide. This is a snapshot of where we are right now in South Carolina as of today. Total confirmed cases over 12,000, and just eclipsed the 500 mark on total confirmed deaths in South Carolina. All right, so just a couple of points on this. Health experts do think that this is probably going to continue through the summer. And most health experts are anticipating there could be a resurgence in the fall of this. So once again, this pandemic really is not going anywhere for a while, and it's something that everyone is going to have to contend with, at least until there's a vaccine and we can sort of get that out in mass, is sort of the this issue going to subside. So many different considerations still out there for businesses as we grapple with this. As I mentioned, employee leave requests, I don't think that you're going to see any kind of decline in that. The Families First Coronavirus Response Act, which provides paid leave in certain circumstances, goes through the end of this calendar year. For all we know, that could be extended. So there's still tough decisions about safety. I think that's where most of our questions probably from clients are coming from at this point. We're still getting a lot of leave questions, but I think most of the questions that we get still concern safety issues and protective equipment, who to notify, how long to send someone home for, all those types of issues, which I think will continue for the foreseeable future. Okay, as far as restrictions go, hopefully most of you are back up and running, and operating at a level that is somewhat close to what it was pre-pandemic. I would say just anecdotally, most of the clients I have talked with are back operational and have hired most of their workforce back. I know some are still in the process of bringing people back on sort of a rolling basis. I know some have had to make tough decisions about more permanent layoffs due to, still what we're seeing from some clients is decreased demand. Some of our manufacturing clients I'm hearing from in particular are still having supply chain issues and demand issues from customers. And so a lot of employers have moved into sort of a phase of, okay, what does our workforce look like more medium term and long term? When is demand going to be back? Do we need to make some permanent layoffs? And as I made reference to earlier, safety remains the most critical issue at this juncture, as everyone is, almost all businesses are able to operate in South Carolina at this point in time, at least under no or limited restrictions. And so making sure that you're providing a safe work environment for all your employees is critical, which we'll dive into here in a minute. All right. So one of the things that we wanted to do today is to give an update on where we are seeing litigation trends. When COVID first hit and some of the new laws and guidance were issued, we as lawyers just did not have a lot of information as to what litigation was going to look like. We were advising clients based upon, our best guess based on previous laws as to how they were going to be interpreted and what was going to happen. We are now sort of moving into the phase where we're starting to receive some data about COVID-19 litigation against businesses, particularly in the context of employment law. And as anticipated, the Families First Coronavirus Response Act, which is the federal paid leave law that I'm sure all of you have been intimately a part of dealing with, it's no surprise that is one of the areas where we are seeing a lot of litigation. And when I say a lot, from my internet research, it looks like from different sources that are trying to compile this information, it's certainly over 100 cases nationwide that have been filed. That's probably greatly underreported. Those are only cases that have actually been filed in court and have become a public record. Anecdotally, through working with clients, I know there's a lot more just sort of everyday back and forth kind of pre-litigation negotiations going on between businesses and their employees about whether or not the employees are entitled to leave and under certain conditions. You'll see a link in the PowerPoint to an article in the state newspaper recently that some of you may have read. It was an interesting article. It was entitled "COVID-19 is Creating Tension Between Workers and Their Employers, and Some Workers Are Suing." There was at least one complaint specifically linked in that article. It was a lawsuit that was filed in York County against a business by one of its employees, and they quoted extensively in that article the plaintiff's lawyers who filed that case, and those plaintiff's lawyers indicated that they had filed a couple of more of those. Just a quick sort of summary of that particular case. An employee at a business in York County, apparently right when the FFCRA was passed, sent an email on April 1st informing her employer, "Hey, my kid's school is closed. I'm going to need to be at home with them during this time, and I'd like to request leave under the FFCRA." And again, disclaimer, this is all according to the complaint. As all of you know, there's always two sides of the story, and we have not gotten to see yet what the employer's defense was in this case. No defense lawyers were quoted in this article in the state newspaper, which I was a little bit disappointed to see. So worker emails on April 1st asking for the leave. Apparently, according to the complaint, a termination or furlough letter was sent on 2 days later to her April 3rd. According to the complaint, that letter was actually backdated, according to them, to March 30th to make it look like it was sent prior to her requesting the FFCRA leave. But her effective date of termination was April 6th. And presumably this was, due to a downturn in business and in needing to let that employee go as part of, a group layoff, although we don't know that. From the employer in that case allegedly also reduced the employee's PTO balance in those days that she was out between when she notified them that she needed to leave and when they terminated her. I think she had 10 hours of PTO or something, which that they did not pay out to her upon termination. So in addition to filing a lawsuit directly under the FFCRA, they asserted a South Carolina Wage Payment Act cause of action in there, which is something that you'll probably see a lot of in these types of complaints, maybe in an attempt to try to keep them in state court, but also the Wage Payment Act allows successful plaintiffs to recover their attorney's fees for bringing a lawsuit, and potentially allows them to get treble damages for the amount of the unpaid wages. So there's a couple of interesting things about this. The complaint, importantly, I think, alleges that the employer never provided any kind of formal denial of the request for the FFCRA leave. It says, no reason was ever given as to why. We don't know if that's true or not, but assuming for argument's sake that it is, I think that's an important thing to keep in mind when you get these requests for leave, that you need to take the request seriously. If the requests are going to be denied for whatever reason, that needs to be documented, and you need to provide really specific reasoning as to why it's denied. Are you denying it on the basis that you have under 50 employees and you've claimed a small business exemption? Are you denying it because the person is not eligible or they haven't provided enough documentation, et cetera? That was something that jumped out at me in the complaint, and it's a very short complaint that doesn't have a lot of facts in it, but that certainly jumped out to me. Another thing that I noticed both about the article that was written in the state paper as well as the complaint filed is that, one thing that you've probably heard Chris and I talk about on these webinars is the fact that the FFCRA does not and was not intended to shield employees from being laid off. It's not an entitlement to paid leave. Even if you were going to have to terminate the person because of a downturn in business. And I think that's probably going to be a very key issue and a very key defense for employers moving forward in these cases, because that seems to be what's going on, and it's not really discussed at all. And if you look in the state paper at the quotes from the attorneys in there, there's sort of no reference to that fact anywhere in the article. The provision about reducing PTO is important to keep in mind. I've been getting a lot of questions about how to handle leave under company policies, and those issues can be really tricky, not only with the FFCRA, but an employee wanting to, even if they don't qualify, wanting to use that for their leave. And so, a lot of the policies that I see, employee handbooks and PTO policies I see, don't clearly address specifically when an employee may have the right to tap into those, and under what circumstances the employer can deny that request. So that was another important element of that case that they discussed in the state article that you need to be on the lookout for. Also in that, so that's the FFCRA. That seems to be where a lot of the litigation is. Also in that state article was reference to a protest at a chicken plant in West Columbia. And the allegation in that case was that a group of employees essentially refused to come to work because of unsafe work conditions. And instead of coming to work, they went across the street and protested what they felt were unsafe work conditions, and allegedly they were fired. I'm not going to get into too much of the specifics of that case, but this has really been going on across the country. Amazon has made headlines about workers, staging walkouts and protests of unsafe work conditions. And there was a high-profile case of Amazon terminating one of their employees. He claimed in retaliation for raising the issue of unsafe work conditions. And a lot of this, as always, is playing out over social media. Just a quick reminder on this: to the extent that you get employees complaining about unsafe work conditions, staging protests, taking to social media, keep in mind that those actions taken by employees, although you could see them as potentially disruptive, could be protected activity under the National Labor Relations Act, which Section 7 of that applies to you even if you're a non-union workplace, and it allows employees to discuss the terms and conditions of their employment. And certainly unsafe work conditions could be one of those areas. And so I think the National Labor Relations Board is going to be taking this seriously. I think we're going to see a lot of that. So if you we'll talk more about safety in a minute, but if you get those types of claims of employees complaining, keep in mind the National Labor Relations Act. And that really, that really applies to social media posts and potential activity with regard to these protests that are going on across the country as well. I've seen a lot of individuals being fired in the last couple of days. There's articles in the Post and Courier and the state newspaper about employees in South Carolina being fired because of what they put on social media in relation to the protests. Again, that can be very delicate. There are all sorts of rights available to employees depending on what they post on social media. So just be careful of that. Some of the other litigation trends we're seeing, everyone has been worried about what happens is, am I going to be sued if one of my workers contracts COVID? There was a case involving Walmart that some of you may have seen. The family of a Walmart employee who died from COVID-19 filed a wrongful death lawsuit against Walmart. And essentially the allegation was that the Walmart employee told Walmart management about his symptoms. They forced him to continue work for a few days prior to eventually sending him home, and he died 2 days later. And the allegations are that Walmart knew that other employees had symptoms and this was a problem in the workplace, and they made these employees continue working. The article quoted the lawsuit, which claimed that Walmart was negligent because it, quote, did not adequately clean the store, enforce social distancing, and notify other employees about potential exposures. I think the sort of failure to notify is really the key takeaway there. We've talked previously about what your obligations are to notify other employees and or customers in the case of confirmed COVID cases, but I think that's the key thing to keep in mind. Hopefully workers' compensation laws and workers' compensation insurance policies are going to take care of most of these direct suits against employers. That's going to be something that we're just going to have to monitor for the rest of the year, how insurance companies are going to make those decisions as to whether or not a claim is sort of work related. We'll just have to see. When I give the legislative update in a minute, we'll talk about some efforts that are going on at the South Carolina State House to bring some clarity to that issue. Another case in Florida where it was alleged that the employer did not provide adequate personal protective equipment. I'm not sure exactly what the cause of action was there, but it might have been, a violation of OSHA standards. But the key thing I wanted to point out in this case was that the employee went ahead and tacked on a claim that he was misclassified as an independent contractor. And although it had no relation to this COVID, I think it's important to keep in mind that if issues related to COVID are mishandled with employees and they're inclined to file a lawsuit, don't be surprised if a former employer and employee brings out, old issues that have gone unaddressed for a long time. So maybe the person was perfectly fine being classified as an independent contractor. All of a sudden you have a dust up over PPE. Now all of a sudden they're not okay with it. Plaintiffs are tacking on other employment claims to these. So just be on the lookout for that. Even more reason to be very careful. Couple more litigation things. Lawsuit in McDonald's brought by a group of employees, kind of the same type of thing. This was a class action claiming that McDonald's, like Walmart, was not doing enough to protect its employees. I'm not sure what the status of that suit is, but I include it here in case you want to look it up and do any research on that. OSHA, this is all in regards to, workplace safety. OSHA complaints. This honestly may be the most likely way you're going to see one of these issues come up. I have, over the last year, handled a number of these cases for employers where current employees called up OSHA and, complained about a safety issue. And this was pre-COVID. It seems like employees are very familiar with OSHA and the fact that they can easily file a complaint with OSHA. It doesn't take much time to do. They don't have to spend any money and go see a lawyer to do it. We have some numbers that really were from our last presentation. I don't have updated numbers on the OSHA complaints, but I have a feeling they're much more than the numbers that we have in this PowerPoint. Most of them concern some kind of inadequate PPE or, or not taking precautions like social distancing and cleaning the workplace and things like that. And OSHA is certainly investigating those claims. One more piece of litigation on safety I'll point out to you is a piece of litigation where a cook at a Texas restaurant filed a lawsuit claiming that the employer did not allow them to wear masks. She wanted to wear a mask, and the employer said, no, our staff is not going to be wearing masks. I don't know if that was they're worried about freaking their customers out, or I don't know what the reason is, but this happened and the employer would not let her wear a mask. She's still a current employee, filed a lawsuit, and was granted by the court in Texas a temporary restraining order, immediately ordering the restaurant to allow her to wear a face covering while at work during the pendency of this litigation. So, that tells me that it's not easy to get a temporary restraining order or an injunction against a business. And so what that tells me is that courts are going to be taking those safety issues very, very seriously. And again, links to all these cases that you can look up if you want to find out more facts on those. Briefly, a couple of brief points on best practices to avoid getting yourself into a situation like some of these companies have found themselves in. I've got carefully consider all requests for leave, but I think this really should be broadened to carefully consider just all requests, whether that's for leave, whether that's a request to wear a face mask, whether it's a request that somebody wants to be moved to a different location of the facility because they're not comfortable. I think given the circumstances we're in, you've just got to pay extra careful attention to requests if they are related to safety, at all. And as it pertains specifically to requests for leave or alternative work arrangements, work from home, just keep in mind that you can't just check the FFCRA box and say, okay, you don't qualify for that, so you don't get anything. There's still a lot of other laws that come into play, the FMLA, the Americans with Disabilities Act. I got an email this morning that apparently there has been a huge increase in requests for ADA accommodations with respect to COVID-19. So keep in mind that even if you're not eligible for FFCRA leave or you don't have any company provided leave, you may have to provide leave as an accommodation under the ADA. Chris will probably talk a little bit about this, and we've talked about it previously, but creating a safety plan, you need a written safety plan. You've got to follow CDC and DHEC guidelines as closely as possible. That ties into negligence, which is what most of these workers are going to claim in these lawsuits, that the business did not act reasonably under the circumstances, and think carefully really before terminating any employees really in this environment, particularly if they've already made a request for leave or they've made any complaints about safety or they're posted anything online. I'll just counsel you to seek legal counsel where necessary with those sticky terminations, because I think it's more difficult than ever at this moment. All right. I'll try to be very brief on these last 2 points so I can turn it over to Chris and so that we have time to address any questions that you have. Paycheck Protection Program funds are starting to run out, meaning that businesses are getting to the point where they've spent all the money they received. And so I'm getting a lot of questions about, okay, this has been a lifeline for my payroll over the last 6 weeks. Money's dried up. I don't know whether we can keep all these people employed. There's no requirement in the Paycheck Protection Program to maintain headcount at any certain levels beyond the June 30th, the 8 weeks, or the forgiveness application. But as with, anytime you're laying people off, consider your options carefully here, as I just mentioned. Be mindful of how you decide which employees are being laid off. I've had some clients ask me about approaching people about retirement and that kind of thing. Make sure that, any layoffs, especially in group layoffs, are tied to business reasons. You've got to keep in mind potential age discrimination and other discrimination issues with layoffs. Still seeing a lot of pay fluctuations. Just keep in mind restrictions on changing people's pay, both under the South Carolina Payment of Wages Act, as well as if they're an exempt salaried employee, there are restrictions on changing their pay up and down based on how much they're working or business demand. So keep that in mind as well. And if anybody has questions about PPP, submitting the forgiveness application, how to count employees, any of that kind of stuff, just please reach out to us on that. We'd be happy to help you. One final thing, and I'll turn it over to Chris. Legislative update. At the federal government, really 2 things are happening. One, the U.S. House of Representatives passed the HEROES Act, does a lot of things. The primary thing is that it's an extension of the Paycheck Protection Program to allow businesses to spend funds beyond the 8 weeks, potentially up to something like 24 weeks. That has stalled in the Senate, which we anticipated. I do anticipate the Senate passing something on that, a potential extension, but it's going to be different than the House bill, which means that the 2 bodies are going to have to get together and come to some kind of compromise, and who knows where it'll go after that. There are a lot of questions about whether this $600 a week enhanced unemployment is going to continue after the end of July. As of right now, that expires at the end of July. And there have been talk about an extension of unemployment benefits, but the economy does seem to be picking up a lot. So I'm not sure how much appetite there's going to be for that in Congress. Final thing is South Carolina is pretty active right now. Both the Senate and the House in South Carolina have created subcommittees on business liability. A couple of the things they're considering: one, a safe harbor, which is temporary and limited immunity as needed to protect a business from exposure to COVID if the employer followed public health guidance. So again, I would not be surprised if something like that gets passed, and that makes it even more critical to follow the guidelines by CDC and DHEC. Importantly, no protection for bad actors. They're going to make that clear, that the protection should not apply if there's any intentional or reckless conduct by an employer. And finally, workers' compensation claims, clarification that on-the-job claims of exposure to COVID-19 are exclusive to the workers' comp system and will not go to civil court. Those bodies are meeting this week, and the South Carolina Chamber of Commerce has really encouraged businesses to let their legislators know of their support for these protections for businesses. So I encourage you to reach out to your relevant legislators or to the South Carolina Chamber of Commerce on that.
All right, so before we get to the rest of the slides, I'm going to go ahead and hit a couple of the questions that I answered, because I think they will pertain to the whole group. And for those of you that asked the PPP questions, I wasn't ignoring you. Perry will take those. I've gotten two questions on EFMLA. They're related. The first one is, what if we've granted folks EFMLA already for the last however long? Do we have to grant it for the summer? EFMLA does not offer any extended FMLA rights other than what is covered as far as leave entitlement is covered under the FMLA. So that's 12 weeks. So if you have already granted and given 12 weeks of EFMLA, then you would not be required to give more. You may have to give additional 2 weeks under the FFCRA for an employee's medical condition. There's situations when someone might get an additional 2 weeks leave that is not EFMLA or FMLA protected. But if it's all for childcare, daycare, schools, then if there's nothing new outside of that, they're not entitled to more than 12 weeks. Another question I got was, at the end of the school year, and now we're headed into the summer, are you allowed to go back and ask, all right, what were you going to do for the summer? And the same requirements apply for the summer that applied for the year. They have to provide you with the documentation that is required for the EFMLA. And that is going to be not only that the daycare or facility that they were going to use for the summer is closed due to COVID-19. It's going to also have to relate to a son and daughter, or son or daughter, and it's going to have to be tied to you or the person who is, there's no other person that can stay home and do this. So those requirements still maintain in the summer. And presumably folks that had children had plans for children in the summer, and those would have had to have been changed due to COVID-19. Now, in regards to employees that are concerned about coming back to work because they're at home with people who have risk factors, that's a situation where I would want you to explore the options with them first before saying you got to come back. The Department of Labor has said employers should be flexible with employees, and I would want you to be able to show that you considered it. That doesn't mean you have to grant it. The options are flexible work arrangements or teleworking or those sorts of things. And so that would want to be something that you could show more on a case-by-case basis. But if the work is work that requires somebody to be present and there are no flexibility options you can offer, and they're simply just not wanting to come back to work because they don't want to expose the people in their household, then your normal rules would apply. And, you would do what you would normally do when a person is not able to come to work and do the work. I would say that might be a situation where you'd want to get counsel involved, if nothing else, to make sure that the communications to the employee would meet what we would want to be able to show that you had considered it before we made the next decision. The last question I wanted to mention was due, South Carolina Unemployment Commission. And if you are going to have any sort of anticipated shutdown, there is a process. They want you to file for all of your employees to get that started. I would obviously distinguish between if it's a COVID-19 situation or some other situation. And just a reminder that the Unemployment Commission, DO, has issued 3 different guidances and resources for employers who have offered employees opportunities to come back, but the employees are refusing it. You want to communicate that to DO. You want to fill out the UB 261 form and mail it to DO where they want it. And you want to follow those guidances, because later on, you have to anticipate DO is going to come back to employers and seek the experience rating payments that they need to from employers for anything that didn't meet the criteria that they established for no increase in experience rating due to COVID-19. And so you want to make sure that you're communicating with DO when there's work that the employee can do and that the employee has not returned and refuses to return. And you want to be able to do that even if they grant the request initially. So I do have one client who paid their employee to stay home during several months of time when they decided it was safer for the outbreak to have that group of employees stay home, but they paid them fully. That employee filed an unemployment claim. The employer, of course, opposed it, attaching the pay records to show that from January to the date that the claim was filed, that the employee had been receiving the same amount of income throughout that time and was getting paid to stay home because that was what the employer considered was the safest prospect for that group of employees. And DO granted the unemployment request. So the employer, I encouraged them to appeal it, and they appealed it, and they just resubmitted the same stuff they submitted, and DO immediately rescinded its grant. So you're going to want to make sure you're doing what you need to do with DO to not only inform them of a situation where there's going to be a closure that'll impact a number of employees that's COVID related, but also let them know when the inability to return to work or to come to work is not due to that, and that the offer is there. All right, so I'm going to hit really quickly just some additional stuff that's come out. Really, most of it I would not say is new, and if you've been keeping up with it, you're in good shape. But OSHA did just issue on May 28 specific guidance on social distancing at work. And I would say that everything I'm reading, and I have been reading a lot and keeping up with this on purpose because I know y'all need us to. Everything I've been reading is that social distancing and those hygiene practices of washing hands and stuff still is absolutely considered the best way to limit exposures. And so OSHA has issued very simple guidance about what that looks like, and it's important for employers to be aware of it. Obviously, OSHA felt like that it was necessary to issue this guidance. OSHA's only issued 2 guidances in regards to COVID-19. The rest have been temporary enforcement memorandums. The first one was OSHA COVID-19, which you've heard me beating that drum for some time, and I'll beat it again a little bit here later. But this is the other one. And so I would encourage you to make sure that it's being followed, as well as any sort of social distance infractions are being dealt with by your people who are on the ground, your boots on the ground, so that later you'll be able to show not only did you have the written policy, but you also had the practice and you enforced it. All right, next slide, please. Okay, so another OSHA update. This is an updated enforcement memorandum. It replaces the April 13 memorandum, but it also duplicates the April 13 memorandum in detail. So I would say, if anything, it encompasses it. The only change from the prior enforcement memorandum that said employers should follow OSHA's COVID-19 standard and CDC's recommendations for employers, and that if OSHA is inspecting or looking into whether or not there is an OSHA violation, is going to be the litmus by which employers are judged. In addition to that, it is also said in this most recent memorandum that it's going to adopt 2 different inspection paths. And so for communities where there is a decrease in outbreak in the community or in the state, they're going to revert back to their normal inspection procedures pre-COVID. But for communities where there is sustained or increased infection or a resurgence of infection, they are going to focus their efforts on those communities, and that is where they're going to be focusing their investigation efforts. They're going to do on-site inspections when it's going to involve a situation of imminent death or outbreak where people are in danger or fatalities, or in regards to specific workforces, health workers, and first responders. So they're going to prioritize those on-site inspections in those areas, but they're going to investigate any complaint they get. And so any employer who resides in an area that has sustained or increased infection or a resurgent needs to realize that OSHA will be focusing on them. Now, and the reason that we wanted to make sure we showed you what the outbreak looks like in South Carolina these days, this week, all that data is from this week, is so that you know, as the HR director or manager, or the person who's dealing with these issues at your workplace, that you would fall into the latter category, the one where they're going to be focusing efforts on. And so I think that's important, because I have heard other people on other employment platforms say, I haven't really seen an increase. People that are in a position to be cognizant of what's being communicated. And I think it's important. Perry and I continue to point out that we want you to be protected legally. And so one of the things as a director of HR you're going to need to keep up with is what the actual numbers say about what is going on in your area. When you're evaluating hotspots, when you're evaluating your daily inquiry forms, or whether or not travel is a problem, you're going to want to know, what's our exposure like? What are we currently seeing? In Greenville County, we're on a huge uptick. We've now exceeded Richland County. So these are things that are important to keep in mind. The other thing is, if we put these measures in place, hopefully we won't have to close again. Hopefully there won't be such an outbreak that they'll require closures again. So please keep all of that in mind. Follow the OSHA COVID-19 guidance. That is something that I outlined in detail, that in the CDC guidance for employers, for workplaces, 2 weeks ago in a post. So it's on the blog. And then also keep up with it and keep up with the exposure in your area, so that the decisions you're making are informed, and you'll be able to show that if you are inspected. Next slide, Brittany, please. All right, another guidance that was issued on May 19, in addition to the one I just outlined that was issued May 19, is when do you have to record? And there's a little bit more explanation about what is reportable on OSHA Form 300 than we had initially. And so that's good. And I will say too, that OSHA specifically said in this guidance that just because you have someone who contracted COVID does not mean you're going to have a citation. And just because you fill out a Form 300 is not going to translate automatically into a citation. So OSHA felt compelled to, let employers know that, to assure them of that. But in situations where you are having a COVID-19 case, a diagnosis of someone in your workplace, you do have to engage in an analysis of whether or not it's reportable under Form 300 and immediately reportable to OSHA pursuant to their guidelines. So first of all, it's got to be a confirmed case of COVID-19. It's got to be work-related. Now, work-related, I'm going to cover that separately. That is a very intricate process, and I'll give you the outline for what you're required to do. But it's going to be hard to discern whether or not it's work-related, and OSHA has said it knows that. And then the diagnosis is not only a diagnosis, but it has to result in any of the following that's listed there: death, days away from work, hospitalization, treatment beyond first aid. So you can see that very likely most COVID diagnoses are going to require days away from work because they're going to be quarantined. I mean, that's what we're seeing. So once you've made that analysis, Brittany, if you could slide on to the next slide, Then you look into whether or not it's work related. And these are the types of things that you would analyze when considering whether or not it's work related. Have a discussion with the employee. How do you think you contracted it? This employee may say, look, I was at an event this weekend and we found out after the fact that somebody had it, or, we were at church, or we were at a family dinner. You may find out quickly that it wasn't contracted there. If it's a single case, that's not going to require much more analysis beyond that. And so, as you note here, OSHA's saying respect privacy, which means it needs to be obviously in a discreet place, and it's preferable that human resources is doing this and not a supervisor. Have a discussion about the out of work activities. Presumably, you might already be asking that on daily inquiry forms that each of your employees present or go through, or that they're required to report to you. I would encourage you to have that process in place. And then look at the employee's work environment for potential exposure and try to determine if this employee could have possibly infected anyone else, and evaluate also how were they working under OSHA's risk categories and the ability to social distance. OSHA says in this guidance that they will evaluate the reasonableness of an employer's determination based upon what the employer knew at the time it performed the analysis, which means if you find stuff out later that's going to impact whether or not you thought it was work-related, OSHA is saying they're not going to judge you on that. It's going to be at the time that you did the analysis, which is, of course, why you're going to want to document your analysis and date it so that you'll be able to show later the timeline. Next slide, Brittany, please. All right. Risk factors that OSHA specifically put into this guidance were social distancing. There it is again. Can you do your job duties by social distancing? If you have close contact with patients or other workers or the public, then there are going to need not only PPE, but also an analysis of additional risk that you need to do for those employees. Another risk area is social conditions. What's going on in our communities, just like we talked about. And then have people traveled to other highly affected places? What was their mode of travel? Have they been in large groups? So the guidance specifically mentioned those three areas as areas that they saw in OSHA the greatest risk. All right. So evidence that has suggested to OSHA that the COVID-19 illness was contracted at work would be after a lengthy exposure to a coworker or a customer who has a confirmed case and no alternative explanation, or exposure to the general public where there is community transmission and no alternative explanation. It is not work related if it's a single worker contracted it, or if it was more likely contracted outside the workforce. So if it is not work related, it does not have to be recorded, and the employer needs to be able to show they made a reasonable good faith inquiry. All right, Brittany, next slide. OSHA reminded employers of the general duty clause, and then it actually issued the 4 elements that said, this is what the general duty clause requires, and all 4 of these must be met. This is important because that's going to distinguish, according to OSHA's guidance, when they're going to issue an alert to you as opposed to a citation. And so if those 4 elements aren't met, then the general duty clause presumably is not violated, or is not violated to the point that they think you need a citation issued. So this was helpful because prior to that, the general duty clause had not been communicated that directly. All right, next slide, please. Okay, I gave you this list because in its guidance, these were the sanitation guidelines and the recommendation guidelines that they identified that should be followed for employees in the healthcare, first responder, and high-risk categories. I'm sliding through this pretty quickly. We're going to make these slides available. I'm trying to be cognizant of our time. All right, so next slide. Again, there's that OSHA COVID-19 3990 guidance. You need to be following it. Perry mentioned it. CDC has some posters that they've recommended, and those are actually linked from DHEC's website and South Carolina DLLR's website. So put those posters up. Have signs up about what employees need to be doing, washing their hands, hygiene practices. Put it up where people wash their hands. look at your spaces, your common area spaces, and decide, you can't do more than these many people in this area and maintain 6 feet distance. So put up a sign that says nobody allowed in these areas more than these numbers. The most common complaints OSHA is getting is lack of inadequate personal protection, or individuals are working with symptoms of COVID and aren't being dealt with. They're not complying with social distance, or they're not listening to an employee's complaints. And so those are the things that can result in an inspection and possible citation. It's important to keep it in mind and approach it very carefully, because I agree with Perry, the most likely place you're going to find a problem would be with OSHA. Next slide. All right, contact tracing. There's a lot of discussion about that. And do employers have to do it, and do they have to report it to the public health agency? We're still finding that you do not need to report it to a public health agency unless you're also the healthcare provider to the employee, right? And so talk to us offline if that's the case. But you do need to engage in your own contact tracing. This is not different from what OSHA COVID-19 guidance was in determining what you need to do to treat, disinfect your workplace and possibly protect other employees. So this isn't a situation where you have someone who has acquired or been diagnosed with COVID-19, and you're going to need to, obviously get them isolated, get them in a mask and gloves. If they need to get onto the medical facility, let them do that. But you're going to want to, after that, you're going to want to get them out of the workplace. You're going to want to have a conversation with them, whether it be in your isolation room or out of the workplace, along these lines of the guidance that's been issued by the CDC, which is, who did you work in close proximity within 6 feet or less, or for a prolonged period of 15 minutes or more? And who were you with in the last 48 hours prior to you becoming symptomatic? Those are the CDC guidelines for how you do contact tracing, and those are the general guidelines. There are specific CDC guidelines for public health entities, but this is the general guideline information that you have from CDC. So think in terms of, who were you working in within 6 feet or more for 15 minutes or more in the last 48 hours before you became symptomatic. And those are the people that you will then need to say, hey, you may have had a possible COVID-19 exposure. You can't tell them who, but you need to say you have had a possible COVID-19 exposure. And, I've been given a lot of advice lately on how to deal with people at the workplace when you've had COVID-19 exposures, what you need to do. CDC has disinfection guidelines that you need to follow. There's a number of guidelines, and we have discussed those in our last seminars. Next slide, please, Brittany. Face masks. So touching on that very briefly, CDC recommends it. There's about 30 states who also require it. Our state is not one, and a bunch of cities require it as well, and some recommend it. Now, you weigh that with, if you're going to require a mask at work, and you have a policy about it, does an employee have a medical reason they cannot wear a mask? You'd follow the same way you would any other accommodation to your policy, of have them get you a medical note that says this, and then consider whether or not you can accommodate it. Evaluate whether or not you can build in some more space with that employee at their workplace. Try to evaluate if there's other PPE that you can use to protect them. Or, in Perry's good point, employers not having masks, but an employee wants to wear one. Initially, there was guidance that said employers are not required to allow an employee to wear a mask if they prohibit it. But here's what I would say about that now, that absent some reason that it would cause them safety issues on site in your workplace, I would let them wear them. An employee who will not work without a mask, I agree with Perry in that Texas analysis. I would say let an employee do what's comfortable for them. If you don't have a policy that's requiring it, let them do what's comfortable. Next slide.
And they did, Chris, just to quickly follow up on that, they did in that case, which I didn't mention, make reference to that fact that the normal kind of general rule is that you don't have to permit somebody to wear one, but and I didn't read the entire opinion on the injunction that the judge ordered, but they seem to think that sort of recent guidance from the CDC has made it such that that might not be applicable now. So I agree with that. It's better to be safe on that.
That's right. That's right. You would like to avoid an OSHA complaint. You're going to want to do everything you can to make the employees feel safe coming to work because everybody's nervous, which is why there's more OSHA complaints being filed. So y'all, we are at 1. We're going to finish up, but those of you who need to drop off, we understand and thank you for coming. So I will tell you the EEOC, don't forget the EEOC, don't forget following their guidance. That was in last presentation. That's on our website. I will tell you that, I don't know if all of y'all remember this, EEOC was ordered by a court some time ago to issue more wellness guidance because their wellness regulations about when you could have wellness programs did not jive with the ACA or HIPAA. And so then they issued regulations that a court said, you need better guidance. And so apparently they're getting around to that now. So if you want to participate in their public meeting on that, or if you want to submit any consideration for them in the notice of proposed rulemaking process, note that that's going on this month. June 11 is the public meeting, and EEOC's website has information about that. Next slide, Brittany, please. All right, so I think that I have talked about some of these. I will hit that I'm continuing to see that employers have not put into place a written COVID-19 policy that they are communicating to their employees, nor a written COVID-19 plan, and both of those things are required. You would want to be able to show that you have those documents if you are subject to an investigation. And you also want to show that you are requiring employees to report the things that CDC and OSHA say they should report for you to determine whether or not you need to implement a quarantine. Another thing that I think is very important is that each position, each type of a position that you have in your workplace needs to be evaluated under the 4 risk categories that are outlined in OSHA's COVID-19 guidance, and make sure that you are issuing PPE and requiring use of it for anything other than low risk. And even low risk, if you're not able to maintain social distancing, predominantly much of the time, you might want to put some protections in there. Testing in the event of an exposure. Yeah, I have very mixed feelings about this. Employers have asked me about it. I think each situation is different, but I'll say from a general comment that a test, if you were to perform testing, are you going to perform it every day? Remember that an employee who comes to work and gets tested, these tests at the most are not being turned around until 3 to 4 days. Some of them are saying 48 hours. The employee's already worked a minimum of 2 days at that time, at the time when they're most infectious. So I'm not sure that testing is the best method. CDC says it's the best method is following the hygiene practices, the social distance, following OSHA COVID-19's recommendations, all of those things. I'm not sure that testing is the best option. There are times when employers will need to do it, and I would encourage you to get some advice on how to do that and what you need to do about that. Retaliation, we've talked about. Workers not returning, we've talked about. I think that's it. Next slide, Brittany, just check and see. Yeah, that's it. So I think all of the questions look like they've been answered. Looks like Perry was answering questions while I was talking. And so, Perry, is there anything else you would want to add?
No, I don't think so. I think I answered all the questions. I mean, I told a couple of people to feel free to follow up with us separately on a couple of specific factual scenarios, but otherwise, for everybody else, don't hesitate to reach out to us with any questions. And thanks again for joining us today.
Thank you. Stay safe.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.